The last 10 pages of John Lennon's FBI file were released in 2006, 25 years after the historian John Wiener first requested them under the Freedom of Information Act. The government had withheld them on national security grounds, warning that their release could lead to foreign diplomatic, economic, and military retaliation. When the pages were finally made public, they contained routine notes about Lennon's associations with British left-wing groups in 1970. That was it. The secrecy had lasted longer than Lennon's entire career as a Beatle. Inside the 281 pages the government had fought so hard to protect was a memo from J. Edgar Hoover instructing that Lennon should be arrested on narcotics charges if at all possible. The file was not about what Lennon had done. It was about what the government wanted to do to him. John Lennon arrived in New York in August 1971 with Yoko Ono, initially to pursue a custody battle over Yoko's daughter Kyoko from a previous marriage. He had come with a tourist visa. He had no immediate plans to leave. New York in 1971 was the city he had been looking for without knowing it, chaotic, creative, indifferent to celebrity in the way that London had ceased to be, full of people making things that had nothing to do with the Beatles or with what the Beatles were supposed to represent. He settled in Greenwich Village. He made records. He appeared at rallies. He met Jerry Rubin and Abbie Hoffman, two of the most prominent figures in the American anti-war movement, and began attending meetings that the FBI was already monitoring for different reasons. By late 1971, the Nixon administration had identified Lennon as a specific political problem. The 26th Amendment had lowered the voting age to 18, adding millions of new voters to the electorate for the 1972 presidential election, voters who were disproportionately opposed to the Vietnam War and to Nixon himself. Lennon and the activists around him were discussing a national concert tour that would combine music with voter registration drives, moving from city to city in the months before the election. The White House understood what this meant. A figure with Lennon's reach, aligned with the anti-war movement, actively working to register young voters against the incumbent president, was not an abstract ideological concern. It was an electoral threat, and it required a response that the normal machinery of political opposition could not provide. On the 4th of February, 1972, Senator Strom Thurmond of South Carolina sent a classified memorandum to the Nixon White House. The memo recommended that John Lennon be deported. It cited his anti-war activities and his associations with radical left organizers. It noted that his continued presence in the United States represented a political liability for the administration. Thurmond sent copies to the Attorney General and to the head of the Immigration and Naturalization Service. The memo was not a legal document. It was a political recommendation, and it moved through the government's channels with the speed of something that everyone in those channels already understood was the desired outcome. The FBI had been building a file since the previous year. The deportation machinery was ready. What was needed was the formal mechanism to set it in motion. On the 1st of March, 1972, the Immigration and Naturalization Service notified Lennon that his visa had expired and ordered him to leave the United States by the 15th. On the 6th of March, formal deportation proceedings were initiated. The stated grounds were a 1968 British conviction for cannabis resin possession, a charge Lennon had pleaded guilty to in London 4 years earlier, paid the fine for, and considered closed. The INS had identified it as a disqualifying offense under American immigration law. Lennon's lawyers immediately filed to contest the proceedings, arguing that the conviction was being selectively applied. that the immigration authorities had routinely overlooked similar foreign convictions in cases that did not involve public figures who had organized against the sitting president. Lennon knew he was being watched before the deportation notice arrived. He said so publicly, on television, in terms that were specific enough to be uncomfortable for the government agencies listening. On the Dick Cavett show and on the Mike Douglas show, he described men in suits who appeared wherever he went, and people who came repeatedly to repair his phones at hours and intervals that made no sense. He was not performing paranoia. The FBI file that would eventually be released confirmed what he was describing, that his activities were being monitored, that informants had been placed inside his circle, and that the Bureau's New York field office was filing regular reports on his movements and associations. He knew. He said so. The government denied it and continued the surveillance. Inside the FBI file, among the 281 pages the government would spend decades fighting to protect, was a directive from J. Edgar Hoover to the Bureau's New York office. It instructed that Lennon should be arrested, if at all possible, on charges of narcotics possession. The instruction was not accompanied by evidence of narcotics. It was accompanied by the understanding that a drug arrest would provide the immigration authorities with additional grounds for deportation, grounds more recent than the 1968 British conviction, and therefore harder to challenge. A federal law enforcement agency was being directed to manufacture an arrest. The word that appeared elsewhere in the same file, describing the broader objective of the operation, was neutralize. Lennon was not being investigated. He was being targeted. What the file actually contained, beyond the directives and the surveillance reports, was a portrait of a man whose political activities were considerably more ordinary than the government's response to them suggested. The FBI tracked his attendance at anti-war gatherings. It monitored his financial contributions to left-wing causes. It noted his associations with Jerry Rubin and Abbie Hoffman, both of whom were already under surveillance for their own activities. It included a handwritten copy of the lyrics to Working Class Hero, submitted as evidence of Lennon's radical leanings, and it contained a report from an informant who had been present at meetings between Lennon and the activist community. A report that noted, in terms the FBI chose not to highlight in its public communications, that Lennon had explicitly stated he would only participate in peaceful demonstrations. That informant later became one of the more remarkable figures in the story of the file's release. When John Weiner's legal battle to obtain the documents reached a critical stage, a government informant who had been embedded in Lennon's activist circle in 1972 came forward and testified for Weiner, not for the government. He confirmed that the FBI's characterization of Lennon as a potential instigator of violence had been false. He confirmed that Lennon had advocated peace. He confirmed that the Bureau had known this and had continued to pursue deportation regardless. An informant who had been paid to surveil John Lennon had concluded, by the time the legal proceedings arrived, that the government he had worked for had misrepresented what he had seen and heard. The deportation case moved through the immigration courts and the federal judiciary across 3.5 years. Lennon appeared at hearings. His lawyers filed appeals. Immigration judges granted stays. The government appealed the stays. The case worked its way up through the system with the methodical slowness of litigation conducted by one side that had the law on its side and another side that had the government on its. Throughout this period, Lennon continued to live in New York, continued to make music, continued to give interviews in which he discussed the case with the directness of someone who understood that the public visibility of his situation was part of his defense. The case was not happening in private. It was happening in the newspapers and on television, and the government's conduct was visible to anyone paying attention. On the 7th of October, 1975, the United States Court of Appeals for the Second Circuit ruled in Lennon's favor. The court found that the 1968 British drug conviction could not be used as the basis for deportation, that it did not meet the legal standard required under American immigration law. The ruling was unambiguous. Lennon received his permanent resident card, his green card, shortly afterward. He was 35 years old. He had spent 3.5 years in legal proceedings initiated by a classified memo from a senator to a president, pursued through a federal law enforcement apparatus, directed to arrest him on charges it had no evidence for, by an administration that had concluded he was dangerous, not because of what he had done, but because of what he might persuade other people to do at a polling station. John Lennon was killed on the 8th of December, 1980. The FBI file closed. It had been open for 9 years. In the months after his death, the Freedom of Information Act requests began arriving from journalists, from researchers, from people who had been aware of the surveillance and wanted to know what was actually in the documents. The government processed the requests and released a portion of the file. What it released was heavily redacted, pages with entire paragraphs blacked out, documents with only the headers and a few scattered words visible. What remained withheld was described in bureaucratic language that said nothing about the content and everything about the government's continued preference for secrecy over accountability. John Wiener was a historian at the University of California, Irvine, who had written about Lennon's political activities in the 1970s. In 1981, the year after Lennon's death, he filed a Freedom of Information request for the complete FBI file. The Bureau released some documents and withheld others. Wiener filed suit with the assistance of the American Civil Liberties Union of Southern California. The case moved through the federal courts. In 1991, the Ninth Circuit Court of Appeals ruled in Wiener's favor on a significant portion of the withheld material. In 1992, the Justice Department sought Supreme Court review. The court declined to hear the case. By 1997, the Clinton administration settled, releasing all but the final 10 pages. Those 10 pages, the government maintained, contained national security information provided by a foreign government, information whose release could cause diplomatic, economic, and military harm. The foreign government was never officially named. It was, by credible and widely reported assessment, the British Security Service, MI5. The documents the British had provided, the American government argued, had been shared under an explicit promise of confidentiality, and releasing them without British consent would damage the intelligence relationship between the two countries. This argument was presented in federal court filings across several years. It was presented as a serious national security concern. Wiener and the ACLU continued to fight. In 2006, a federal judge ordered the release of the final 10 pages. The government, having spent 25 years and considerable legal resources protecting them, complied. The 10 pages contained notes about Lennon's associations with British left-wing organizations in 1970 and 1971, the period before he moved to America. They described his attendance at political events in London. They noted his contact with figures in the British labor movement. There was nothing in them that posed any conceivable threat to national security. There was nothing in them that would have embarrassed a foreign government. There was nothing in them that explained, or could have explained, why 25 years of litigation had been required to make them public. The government's characterization of the documents as sensitive national security material had been, by any reasonable reading of what was actually in them, without foundation. The secrecy had not been protecting information. It had been protecting the government's record of what it had done with the information it collected. John Lennon's FBI file is available today on the Bureau's own website. All 281 pages, searchable, downloadable, a matter of public record. What it documents is a government that identified a musician as a political threat, directed its law enforcement apparatus to find grounds to arrest him, monitored his activities through informants and surveillance, pursued his deportation for 3.5 years, and then spent an additional 25 years fighting to keep the record of those activities sealed. The word that appears in the documents to describe what the Bureau intended to do is neutralize. What Lennon had done to warrant neutralization was oppose a war, register voters, and write songs. The file was not about what he had done. It never was.